This Honorable Court of Appeals of Tennessee is in session. Please be seated.
Good morning. Excuse me. Good afternoon. Good afternoon. I'm a little confused. Some would say I've been confused all day. Welcome to the Court of Appeals. Glad to have y'all. I think it's just y'all. So I will dispense with our usual statements about procedure and so forth, because y'all know what you're doing. No need to jump through all those hoops. But I will tell you, though, just as a reminder, all this stuff's being live streamed. So whatever it is that you don't want out there, don't say it, because as soon as you say it, it's gone. So some people don't realize that and have some rude awakenings a little later on. Okay, y'all ready?
Yes, Your Honor.
Angie, if you'll call the first, or this case, and then we'll call the next case.
Alan C. Cartwright versus Thomason, Hendrix, PC, et al.
All right, Mr. Para, you want any rebuttal time?
Yes, if I could not blast you completely, maybe. If I could have about 5 minutes reserved.
5 minutes of rebuttal.
Just trying to contemplate what it is I would be willing to say to a court and not want out on the internet. I'm not sure what that would be exactly. That would be embarrassing. Anyway, but
You would be surprised.
I'm sure I would be, but hopefully you will not be by anything I have to say this afternoon. I'm Lucian Para. I represent the defendant lawyers and law firms, and as I said, I would like to reserve 5 minutes. To start with, the issues before the court, we take the position very simply that the court has the authority to reverse the trial court's holding that the TPPA doesn't apply here, and then to evaluate the plaintiff's response under the TPPA, and then to dismiss the plaintiff's complaint. That said, I want to focus my argument on the trial court's error. The trial court here chose not to apply Tennessee's statutory test, ignored the TPPA's plain language, and instead turned to California case law, interpreting quite a different statute. And then, having done that, they established a rule we contend is unsupported by the language of the Tennessee statute. And specifically, the trial court said was, the court finds that while an attorney representing a client in a judicial proceeding may qualify as a person who was exercising the right to petition pursuant to TCA 2017-104A, an attorney who's being sued for legal malpractice and fraud by his former client can never, the trial court said, satisfy the first prong of the test, and therefore has no standing to file a petition under the TPPA.
Let me pose you a question.
Certainly.
Does that issue require evidence? Does the resolution of that issue require evidence?
Well,
or is it as a matter of law?
I think it is a matter of law. I mean, we are admittedly in new terrain here. The TPPA is new. And we were required to carry a certain burden, let's put it that way. But I don't think there was any dispute about the facts that would support the application of the TPPA. But I do think it's a question of law, much like, for example, whether a statement is defamatory is a question of law for the court. So I don't know how else to answer that question. I will say, you know, it's an odd statute in the sense that it's purely procedural, right? It says that once the threshold is passed, and we don't think there's any question the threshold was passed as a matter of law, then the burden shifts to the other side to make a prima facie case. Now, at that point, that's actually a more interesting question of whether they got to put on evidence. I think prima facie case is, anyway, we're not there. We won't talk about that today. But I think in the first instance, frankly, I think it's a question of law, but I don't think there's any question that on the record here, it's very clear. If it were a question of fact, it's for the court to resolve. There's no question about that. And that whether it's a question of law or a question of fact, it is for the court to resolve, and it was shown here.
Well, what was in front of the court
Well, what was in
that
front of the
that
court?
court could resolve this issue?
Well, the allegations of the complaint, the amended complaint, for one.
Just allegations.
Well, that's true. I understand that, but that would be true in any TPPA case, after all. And the
Well,
context.
In most of those cases, the status of the actor is not at issue, as the status is here. Status perhaps is not the right way to phrase that. But here you've got the lawyer involved.
I'm not sure
lawyer.
how that goes, frankly, Your Honor. I don't mean to act dumb, but I don't understand
Well,
how that goes.
I'm not sure that I'm even asking questions that are pertinent, to be honest, because
I'm not suggesting
I've thought myself around in circles.
I'm not suggesting they're pertinent or not pertinent or whatever, but what I am suggesting is that the facts that in any TPPA case, it is, first of all, intended as a way to expedite the resolution of abusive litigation, no question, and a certain kind, a very particular kind, all right? And all that the statute requires by design is that that be shown to the court in order for the court to invoke and apply the TPPA and move forward. Now, if it's a matter of fact in the sense that you would both put on proof on that, that would defeat the whole purpose of the TPPA. Now, once the trigger is pulled, and that's where this case went off the rails, is the court said the trigger wasn't pulled, then you get into this second stage of where the plaintiff here has to put on a prima facie evidence to make out their case, that they can make out their case, excuse me. So our view is pretty simple, is that, first of all, I've already said this, I guess, but that it's a procedural statute. I want to go also to the point that it has to be broadly construed. No question that the legislature's instructed the courts to broadly construe it, that it is procedural in the sense that it doesn't change, repeal, affect the substantive law, okay? It's only a procedural way for certain kinds of cases to be addressed. And also that the questions here that the court relied on, or excuse me, the law the court relied on out of California is simply inapplicable because the California statute has nothing to do with our statute in the sense that he plucked out language in furtherance of, I guess I have to go find that in my notes, in furtherance of the right to petition, and that's not in our statute. The courts out there in California have relied on a particular language in their statute that's not required here. And he created an exception for a particular kind of case, a kind of case where it's a client's legal malpractice case brought by a client against a lawyer. Well, there's nothing in the statute to support that, Your Honor. And by the way, before we get too far gone here, let me point out too that there is an express exception in some states that would do exactly what the plaintiff here, Mr. Cartwright, wants done. The truth is, in Texas, and we've gotten a new missive from Mr. Duncan in the last 24 hours on that subject, about which more in a second, but that statute that he points to in Texas, there's an exception. There's an actual exception now in the statute. We have an exception in Tennessee's statute. It's about state government enforcement actions. Those are not covered by the TPPA. That's over in 108.1, I think it is. I don't think it's A. I think they're numbered with numbers. But let me turn for a moment to this question about party. The question, we've had a number of questions here raised about whether my client is a party that can raise this issue. It's been raised by at least one of the plaintiffs in these cases, that the party has to have been a named party in the prior litigation. Well, candidly, that's just nonsense. The statute applies to matters far broader than litigation. It can apply to speaking at a public meeting. So it's not necessary that the party cannot refer to that, okay? Secondly, the word party in that same sentence refers to the party who may bring a petition, that party. And so that person, that party, that entity, is the one who must be referred to in the other use of the word party. So that's just not a legitimate argument here in terms of why we would not be a party. There's a lot of talk about whose rights my clients were raising. The truth is, there's nothing in the statute that requires that the rights that be raised, that are in question, that are in the conduct that's at issue, that right has to be the right of the person who is bringing it. In other words, it's the right. It's not that party's right. And certainly there are many instances, this is one right here, right now, this minute, where one person can assert the rights, can exercise, that's the verb used, or the noun used in the statute, can exercise another person's right, okay? So whether it is, in this instance, whether the right was my client's right, or their own, the lawyer's own right, is simply immaterial. Now, along the path, you're also going to hear
Even though it's being exercised as a lawyer, by a lawyer.
Yes.
For a client.
Yes, that's exactly right, Your Honor. The truth is, we've got case law going back to 1963 that says that lawyers themselves have a right to petition the court on behalf of clients. That is their right when they're exercising the right for their client. The NAACP versus Button case. This goes back decades and decades. But it doesn't matter because the statute doesn't draw that distinction. The statute just doesn't draw that distinction. Finally, let me
ask you.
Sure.
Here you talk about the statute is to really protect abusive litigation where a party has expressed protective speech. In the context of this case, what is the protective speech that you're attempting to protect?
It's not only protected speech, although you could argue that the right to petition is a species of speech. So it's the right to petition that's at issue here, Your Honor, and the right to petition is a protected constitutional right. In my opinion, both by individuals who are represented by lawyers, they have that right, as well as the lawyers. But the right to petition here is the right to come to a court and ask a judge to grant the petitioner the right. That is the right to petition.
Yeah, but in this case, you're attempting to dismiss their action that they brought against your clients, and you're arguing, in effect, that this is abusive because the speech that your client engaged in was protective speech that deserved protection under the TPPA.
That's
I'm
right.
trying to figure out, what is that speech?
It was bringing of the claims in court on behalf of the plaintiff in this case. That's what it was. It was the Mitchells bringing, the law firms and Jerry Mitchell, and in one narrow instance his son, bringing lawsuits on behalf of Mr. Cartwright. That's what it was. And that's clearly covered by a right to petition. And the claim we make is that Tennessee substantive law protects my clients from this lawsuit, that it is an unfounded, unjust lawsuit, that it is not supported in Tennessee law. And because of that, and because the TPPA provides specific protection when the right to petition is involved, that because it's that kind of lawsuit and because it meets the other criteria of the TPPA, we can bring a TPPA petition. That's what we're talking about here.
Under your construction of the TPPA, would a client ever be able to bring a malpractice action against their attorney?
Absolutely. No question, Your Honor. This is, with due respect, Your Honor, we hear this a lot, particularly in the Garner's brief. The Garner's brief is almost all about this. And that is that they suggest that somehow we're using the TPPA to insulate my clients from liability, to avoid liability. No, that is not the case. The TPPA does nothing. In fact, it says specifically in Section 108 that it does nothing to affect the substantive law of Tennessee. All right? And so our position is these claims by Mr. Cartwright, whether in malpractice or whatever, are unfounded. They're unfounded in Tennessee law, and we want a quick hearing on it because our position is they involve the right to petition. The TPPA covers that and gives us a right to a prompt and expedited treatment of that because those kind of claims that are unfounded are so often abusive. That's the point. Okay. I think I don't know where I am on my time.
You used your time.
So if I got any time left for rebuttal?
Yes, you do. You still got
Okay.
your rebuttal
All right,
time.
good.
You were
Thank you.
answering
Okay,
Judge
well, I will sit
Armstrong's
down.
question.
Good afternoon.
Good afternoon.
May it please the court, Tony Duncan of the Nashville Bar. I'm going to step back a little bit, Your Honor.
Good
And
to
I
have
would-
you, but let me ask you, follow up on Judge Armstrong's question there. If you will, I hate to mess up with your argument because I know you've thought about what you're going to say,
Oh,
but
and
let's say, following Mr. Para's line of thought, this reasoning is to protect his clients from these invalid claims. What does that do to a substantive malpractice claim, though?
exactly, and I think I can answer, but I need to back. That's
Sure,
really
you go ahead, do
sensitive.
whatever you need to do.
Backing up a little bit. It just occurred to me, I know we're in this past season of epiphany. It occurred to me just now as an epiphany that an attorney has no constitutional right to represent another person in court. They can represent themselves. They have to be licensed. That's a privilege. So when a lawyer is representing a client, another, they have no constitutional right to represent that other person without being licensed and privileged. Otherwise, you'd never have UPL. That would be an unauthorized practice of law. So then you go back to the plain language of the statute. I would submit that the construction that the appellants are offering here is strained. Because you go back to the plain language of our statute, it says that you have, first off, this is not a slap suit. It's not a strategic lawsuit against public participation. It's a lawsuit against attorneys for fraud and legal malpractice. So to answer Judge Armstrong's question, is those attorneys under the statute's plain language were not exercising their constitutional rights in those lawsuits, those prior lawsuits. They just, as a matter of law, they couldn't. As a matter of fact, they couldn't. So that ends their argument right there. Further, what kind of Pandora's box are you going to be opening up? Because what if a lawyer misses the statute of limitations? Wouldn't that be of the right to petition, albeit late, under this strained construction? And I would submit that the trial court below followed the law under 20 dash, let me find it here. The threshold question of 2017-105, subsection A, requires the trial court to determine whether or not the act even applies. And a panel in this court determined that in the Rice versus Rock Creek construction case. It's an Eastern Section case. It's a 2021 Eastern Section case, case 1513, that was decided November 1st, 2022. Now, the appellants here are trying to eat their cake and have it too, and here's why. They filed this TPPA petition, albeit late. It's almost 3 years after the complaints were filed, not within 60 days. Then in that TPPA petition, they asked the trial court to consider both Texas law and California law. And I remember Judge Davies, the look on his face when I'm like, Your Honor, I have a California case. And he kind of wrinkled his nose up. And I said, the reason I have that case is because the defendants have cited California law. And it was the Loan Vest case. And it says that when an attorney, when commits malpractice, that doesn't fall under California's anti-SLAPP statute. So Judge Davies followed the law. And now you kind of have sour grapes for people, or from the defendants, because he looked at the persuasive authority that they asked him to look at.
You said something a moment ago, and Mr. Wade, I want you to address this when we get to you. Now, in the next argument. But you said in this situation, you've got allegations of malpractice plus fraud. Mm-hmm. That was the reasoning for my first question about evidence.
Okay.
Because I can see situations where, as a matter of law, a simple malpractice action might be governed by the anti-SLAPP statute, or may not, who knows, because of the status of the lawyer and the client. But in this instance, you go further than just malpractice, you're alleging fraud as well. Does the fraud, the allegations of the fraud, or the evidence of the fraud affect this? Does it require proof so that the status changes some?
It might and it could, and the plain language of the statute allows for limited discovery, I believe as the trial court deems fit, but it allows for, it says discovery state, but then you may have limited discovery on certain issues, which might be for fraud, or might be for anything else. And like Judge Davies asked me once, did I think it applied all the time? And I will tell you, I took the position that I don't think it does I don't think the TPA would not apply all the time sometimes, because you might have a lawyer that goes and says something to somebody. But here, when you're talking about actions that were done.
Well, that's what I'm trying to get
It's still,
to.
it's a
In this
statute allows for
situation,
discovery.
it's not like, okay, you missed a filing deadline. That could be malpractice.
Mhm.
Here, you've got egregious violations alleged.
Yes.
Breaches of fiduciary duty and such.
Correct.
Do those allegations change the way we analyze this case? And if so, does it require proof?
I think it could, yes. When you have fraud, you're going to have to. Otherwise, they're going to have people, you're going to have lawyers, you don't want to open up, I don't think.
Well, and let me ask you one more question.
Yes, sir.
Before you answer. And do you have to have that proof before you can answer whether the statute is applicable?
I think so. But I don't think you even need to get to that, because last night I was looking at the acts, and I was comparing. The appellants want this court to focus not on California, even though they brought California to the mix, but Texas. And our statute is similar to Texas. But I would submit, though, that House Bill 527, which the Texas legislature accepted legal malpractice claims, didn't change any of the other wording of Texas's TCPA, the anti-SLAPP statute. It doesn't give a reason why it's changed, but I think it's a fair and reasonable inference that the Texas court's interpretation did not meet with the intent of the Texas legislature. I think that's why the Texas legislature changed that, because the courts were saying, oh, you've got these malpractice claims, legal malpractice claims, that apply to these anti-SLAPP suits. We already know that Texas just said no, effective September of last year. I think that's clear evidence that the legislature there thought that anti-SLAPP statutes don't apply to legal malpractice cases. There's also, I can distinguish these two statutes. For instance, under the TPPA, 20-17-108, subsection 6, it said nothing in this chapter, chapter 17, creates a private cause of action. That's not in the Texas anti-SLAPP statute. Then you backtrack and you look at 20-17-102, and that's the stated purpose of our anti-SLAPP statute, the TPPA. And if you notice, the difference between Texas's purpose and ours is there's an added sentence at the end, and it qualifies the purpose of our anti-SLAPP statute. And it says, I quote, "This chapter is consistent with and necessary to implement the rights protected by the Constitution of Tennessee, Article 1, Sections 19 and 23, as well as by the First Amendment to the United States Constitution, and shall be construed broadly to effectuate its purpose and intent." So you have that limiting or that qualification of our anti-SLAPP statute to constitutional rights. Well, then you look at 2017-109, and it says that our anti-SLAPP statute is to supplement those existing constitutional rights. And then I'll take us back to 2017-108, subsection 6. It says, nothing in this chapter creates a private cause of action. By the plain meaning of this statute, a court would have to look and see what constitutional rights the appellants here would have before the enactment of the TPPA. Would they have had any constitutional rights that would oppose or served as a defense to this lawsuit? I would submit to the court, no. So when you do that, that totally takes the TPPA out of the equation. Because if they don't have any rights that would have existed without the TPPA doesn't give them any. Those constitutional rights have to have existed before the TPPA was enacted, went into effect. That's the plain meaning of our statute. It's different than Texas's. And I think our legislature carved it out. It's fair to assume that they carved it out like that because they realize that a lawyer committing malpractice and fraud is not exercising a constitutional right. They're just not. So and that goes back to, there's in the National Bar Association, they do the appellate practice manual. It's worth its weight in gold. And I was at a CLE not too long ago up on the hill in front of the appellate court judges in the middle section, and Donald Caparello was talking. And they were talking about, I'd forgotten about it, but it's called the tipsy coachman doctrine. And it's a Georgia case, actually, but Tennessee follows it. But the gist of it is if a trial court gets to the right conclusion or decision, no matter how they get there, even if it's maybe not the way an appellate court might want them to, but if they reach the correct decision, then the appellate court will affirm it. Well, whether the trial court here followed Texas law or California law or followed Tennessee law and looked at that threshold question that's got to be answered, whether or not the act applies, which we have to ascertain the General Assembly's intent, and you do that by the plain language of the statute. That's where you look at that. Well, the plain language of 2017-105 says that it puts the burden on the petitioners, who are the appellants. And then they have to demonstrate that they were covered by the TPPA. Well, the trial court here determined that they didn't meet that burden. They never got through that door, that they have to walk through. They didn't get through that, so ergo, it just doesn't apply. And the trial court made the determination that a lawyer, when they're committing malpractice, and that takes me back to a lawyer has no constitutional right to practice law. That's a privilege. So the defendants here weren't exercising their constitutional rights. It was the parties whose constitutional rights were being exercised. Have they been sued? And a lot of times, and I'll butcher the name, but it's the Natagam, I believe, but it's the one where one of the reasons, the classic example of our anti-SLAPP statute is you have someone that goes to a dentist, a doctor, a car dealer, or whatever, and they have a bad experience, and they post something on Yelp or on the internet that says it gives them 1 star, right? And then you have these businesses who generally are more well-heeled, have more money, are able to bring a SLAPP suit to try to quash these people's exercise of their First Amendment rights. That's the classic example. So now you may have others because life just kind of has a way of throwing different twists and turns at you. But the plain language of our statute says that a person has to be sued for exercising their constitutional rights. The appellants here, the petitioners below, weren't exercising their constitutional rights. It was my client. And they were representing him. And then when they committed the malpractice and the fraud, they got sued for it. The appellants have the burden here of showing what the legislative intent was. And they haven't shown that. No committee meetings, no hearings. I haven't found anything either that would say that it would cover a malpractice case. They just haven't. And I think the fact that when they're saying, look at Texas, well, look at Texas. I don't think Texas stuff hurts us because the legislature there changed the law because they thought the Texas courts had made a mistake and had construed it too broadly. And then you look at where our act doesn't create a new cause of action, it just supplements what already existed. So for those reasons, we would ask this court to affirm the trial court below their dismissal or their denial of the TPPA petition. Thank you.
Thank you. I think you've got 5 minutes.
Thank you, Your Honor. First of all, let me be clear about why this lawsuit lacks merit. These questions are not before you today, but this claim for malpractice was brought years after the 1-year statute of limitation had run. It was also brought in derogation of judicial estoppel and estoppel. Those are our defenses on which we filed a motion to dismiss. And by the way, estoppel is based on the estoppel here is based on the notion that the judicial estoppel is based on the notion that this gentleman, this plaintiff, gave affidavits to a court that directly contradict the claims he's going on today. Now, that's not before you today to adjudicate, but our position is that that's the basis. And the court raised the question about, why was this abusive? That may not be quite what the court asked, but it is a legitimate question. And so that is the reason. Now let me back up a step to the statute. The statute says if a legal action is filed in response to a party's exercise of the right to petition, that's the trigger. And then we may file a petition. The court said, no, this doesn't fit. And it doesn't fit because I'm pulling this California case law in, and the California case law uses different language, which has a requirement that has been teased out in the case law that the conduct has to have been in furtherance of the right of petition, and built upon that, the notion that it had to be in the client's best interest, or not in the client's best interest. That's all case law in California. We got none of that. We got none of that. There's nothing in Tennessee to support that. No Tennessee case law, no Tennessee statute to support that. Now, for a moment, let's talk about Texas. Now, we do submit that if this court felt the need to look to other jurisdictions, I don't think it has to, Texas is a good place to look, and this court has identified that. Doe versus Roe from this court has made it clear that the Texas law is almost identical to ours. That is true. That is factually true. And Texas courts read their law to mandate the application of their law, identical to ours, to legal malpractice cases until the legislature amended the law this last year. And so yesterday, the filing that Mr. Duncan made, in our view, it violates Rule 27. But and frankly, it introduces a new statutory construction argument that he's never raised before. But candidly, I want to thank him for raising it because there's several things he's highlighted. He's highlighted the substantively identical nature of the Texas and Tennessee law as written before the 2023 amendment. He then doesn't dispute, there's a long footnote on one page of our brief with all the cases in Texas that come to the result we seek here based on the law, on the language of the law there that's identical to ours. He doesn't dispute those cases. I've searched his filing the other day, the new brief he filed, for some argument that those several cases from Texas were wrong. That's not in there. They had to change the law. Third, that's the third point. In Texas in 2023 actually enacted a statutory exemption to carve out legal malpractice claims. We don't have one, they do. They had to do that to change the law. And the Texas, by the way, he also points out for context that the Texas legislature only did this after the Supreme Court in the Winstead case down there had before it this very question. It was briefed, it was punted. And within months, the Texas legislature then said, no, we're settling this. And by the way, they didn't settle the other case you're going to have in a few minutes. The Youngkin case, where a non-client sues. They didn't change that law, but they changed the law on clients. Last thing on constitutional rights. You know, the notion that Mr. Duncan offers that because of the existence of the unauthorized practice of law, that I don't have a constitutional right to petition the court flies in the face of lots and lots of law in this country. I mean, the Button case is about solicitation case law. And it says that whether I have a client or not, I have a right, a constitutional right, to solicit cases. Now, can it be burdened with certain limitations? Sure. Darn near every constitutional right can. Sure, we got advertising regulations, there are times I can, times I can't solicit. But just because the notion that somehow I have no right to petition because I'm licensed, there's no basis in the law for that, members of the court. That's all I've got. Thank you for your time.
Thank you. Thank you. Gentlemen, we will take this matter under advisement and do our best to get you an opinion as quickly as possible. Ms. Angie, you want to call the next case?
Alice Cartwright Garner et al. Versus Thomason, Hendrix, Harvey, Johnson, and Mitchell, PLLC et al.